All right, good morning. How are y'all? Cold? Is it cold in here? I guess they haven't. I don't know if they've switched the temperature yet or not, but it's always weird this time of year. Anybody have any announcements? Anything to share? Nothing? No one? Y'all just ready for me to get into the lecture then? Any questions on anything we're doing? Nothing? All right, okay. Well, if everything's going that well, then let's jump into it. So this week we're going to talk about criminal law. You have one quiz and one discussion question. That's all we have for this week. So when we're thinking about criminal law, we got to switch gears a little bit because up till now we've been thinking about everything we've talked about is civil law. So we've been talking about in civil law the rights and duties between citizens. We've talked about that the burden of proof in those cases is preponderance of the evidence, and that the purpose of most of the things in civil law is to provide citizens with remedies to address their injuries or be compensated for wrongs that have been done to them by others. This is totally different. So in criminal law, we're going to get into crimes against society. And whereas in civil law, the penalties were things like having to compensate the person that you've wronged or things like that. In criminal law, the penalties are things like loss of liberty, even all the way up to death. The burden of proof in criminal law is beyond a reasonable doubt. Y'all remember that? And the purposes, whereas the purpose in civil law was more compensation, redress of injuries, the purpose in criminal law is to punish, deter others from doing similar acts, rehabilitate people who have committed crimes. So totally different purposes in the way we look at civil law versus criminal law. So I mentioned the burden of proof in criminal sanctions. Remember also that the same act could result in criminal liability and civil liability. And we talked about the OJ case, how that was an example of where he was charged with the crime of murder, found not guilty, but he was also sued in civil law for the tort of wrongful death, and he was found civilly liable for that. So the same act could carry criminal and civil consequences. Crimes are basically grouped into a couple of categories or classifications. You've heard of felonies and misdemeanors. Misdemeanors are less serious crimes that, and it's going to vary by state, but generally misdemeanors would fall into the category of crimes that are punishable of prison up to a year. So if the penalty, I'm having trouble talking this morning, if the penalty is prison for less than a year, that's a misdemeanor, or a fine, or anything less than that. Felonies are the more serious crimes, and they're generally classified by things that carry penalties where you could be in prison for more than a year. So felonies and misdemeanors, felonies being the more serious category of crimes. All right, if you remember when we, in civil law, when we talked about specific torts, for example, we broke those down into certain elements, right? So when we were talking about the tort of assault, you had to have an act that placed someone in fear of being hit or being contacted in an unwelcome way. Criminal offenses are the same way. They're going to be broken down into kind of elements, and those are the things that would have to be proven at trial by the prosecution. Which reminds me, let me back up for a second. Another big difference in civil law and criminal law is that who's the plaintiff in criminal law case? Every time, the government. It's always the government. So it'd be, Yeah, state of Georgia, if you violated a state criminal statute, if you violate a federal statute, then the plaintiff is going to be the United States of America. So when we talked about earlier in the semester when we were looking at all those Trump cases, he's charged in Georgia with violating Georgia's RICO statute. So the plaintiff, it's the state of Georgia versus Donald Trump. In the classified documents case, that involves violation of a federal statute. So that case is United States of America versus Donald Trump. So again, the plaintiff and the defendant are going to be a little bit different in a criminal case versus a civil case. So when we're breaking down, or when we're looking at crimes generally and what has to be proven, usually we're going to get more specific, but generally speaking, crimes require the performance of a prohibited act. The Latin term for that is actus reus. I'm not testing y'all on that. And then they require a certain state of mind. And the Latin term for that is mens rea. So we got to have an act, but we've also got to have a certain state of mind that the government has to prove as well. And when we're talking about a criminal act, for example, it's easy to conceive of like if I steal Yulia's phone, the act was that I stole her phone. A criminal act could also be an omission, like not acting on something. If I fail to file a tax return, that's a crime. I didn't do an act. I withheld something that I was supposed to do. So the actus reus could be an affirmative act, but it could also be an omission or neglecting to do something. State of mind, though, is broken down into some different categories, and it kind of goes along a spectrum, okay? And the state of mind that's required for each crime is going to be defined in the statute. All right, so here's kind of how that works. I'm going to go from one end of the spectrum, which is pure intent, meaning my state of mind was I meant to do what I did, all the way down to the other end of the spectrum. So intent, that is one level of mens rea or state of mind that could be required. Again, the statute will say which one is required, but intent. Murder, the intent is to take the life of another. For theft, the intent would be the taking of another's property. The mental state would be that I knew that was Julia's phone and I meant to take her phone. Intent. Sort of the next level down from intent is this idea of recklessness, meaning I didn't intend to do it, but my actions constituted a conscious disregard for a substantial and justifiable risk. If I go 150 down University Avenue, I'm not intending to crash into anybody or hurt anyone, but I'm sure as hell being reckless. I'm exhibiting a conscious disregard for the safety of others. So I might be violating a crime that requires the mental state of recklessness. Sort of a rung down the ladder is criminal negligence. So I wasn't necessarily reckless, but I was still negligent. And this borrows from civil law and tort law, this idea of negligence, that I had a duty of care to others and that I breached that duty. That could also happen in the criminal context. So criminal negligence. And then at the bottom of the spectrum is I had no intent at all. Y'all remember the idea of strict liability from tort law? That does exist in some crimes too. And again, the statute would say, it's not that the government, if they arrest you and charge you with a crime, gets to pick whatever state of mind they want to prove. The statute says what the state of mind is that they've got to prove. So there would be some things that would require no intent at all. There's some environmental statutes, for example, on the federal level, where it doesn't matter if you intended to discharge toxic waste into the rivers of the state of Georgia. You did it anyway. You could be criminally liable for that. If that strikes you as, I don't know what the word is, unfair or un-American or just maybe wrong that I might be criminally liable for something even though I had no intent at all. I mean, it's not very broadly applied, but it does exist. There's just some things that the government says doesn't matter if you had any intent or not. If it's usually stuff that would affect public health, safety, welfare, very serious things that have very serious consequences. Let's see. Corporations can be criminally liable as well, even though they're not people. We still can impose criminal liability on them because if the agent or employee or officer of a company does something that is criminal, then the corporation can be held liable for that. I mean, obviously, it can't be imprisoned, but it can be fined or it can be denied some privileges or limited in other ways. Let's skip down to types of crimes. There's some point in your outline where it skips around a little bit. Do y'all have types of crimes next in your outline? Okay. And then below that, do you have types of crimes? Yeah, that's what we're, okay. When we depart from it, let me know, because I want to point that out. I was looking at your outline last night, and it's different from the one I'm using this morning. I don't know why it's out of order. All right, so we're going to look at sort of types of different crimes. Violent crimes, just what you would think. There's nothing tricky here. Murder, rape, assault and battery, robbery, things like that would be classified as violent crimes. Crimes can also be classified or broken down in terms of degree, like you've heard of first-degree murder, second-degree murder, first-degree assault, things like that. The difference in the degrees is the seriousness of it. And the statute would define, so in other words, there's a separate statute for first-degree murder, second-degree murder, and so on and so forth. And that would spell out exactly what would have to be proven for those crimes. So it's not like crimes, sometimes in tort law, for example, we defined what negligence was, but negligence could be applied in many different ways. And it was a little bit ambiguous on purpose. Crimes are more specifically defined in terms of what the government has to prove to make out that crime. So the difference in first degree and second degree murder is going to probably it's going to have to do with, they're both going to require intent to take a life. But off the top of my head, I think they're going to depend on like your degree of premeditation. So maybe you and I got in a fight in the parking lot and I hadn't really planned on killing you. I killed you on purpose, but maybe it had to do with a fit of rage or rather than me planning on killing you and coming to campus that day with the intent to kill you, waiting on you, something like that. I think it would have to do with, there would have to be something mitigating in there to knock it down from first degree to second degree. And I bet it would have to do with premeditation. I don't want to like if you got into a fight with someone, killed them, it wasn't your intent to kill them, was that not manslaughter? Could be. Yeah, the less intent you have, it's going to be defined probably as a different crime. So manslaughter is, the taking of a life of another, but you're lacking in the mens rea for manslaughter would be something like recklessness or negligence or something. There'd be something mitigating in there that wouldn't rise to the level of intent. So that would be the difference in that. Yeah, so that's a good question, which was, is it up to the prosecutor to decide? Yeah, I mean, when you get arrested, they'll have to charge you with something, but that can always be adjusted, or you could be charged with something else. So say they arrest you for murder, but then they decide when it comes closer to trial that they might have trouble proving murder. They'd rather try to prove that it was manslaughter, so they would drop the murder charge and try you on manslaughter. But yeah, it's up to the prosecution to decide. The defendant wouldn't have any say in what he was charged with. Yeah, it's a good question. A lot of times you could be arrested for something, and then the prosecution could look at what you did and try to see how many things they could charge you with. I mean, they could do that, depending on what the evidence showed. So those are the violent crimes. Your outline says also, Caleb, that the classification might be have to do with the weapon or the level of the victim's pain and suffering. Those could be factors in deciding whether something was first degree, second degree, and so on. So property crimes, burglary. I don't know about y'all. I always thought of burglary as stealing something, but burglary actually, as defined in most laws, is the breaking and entering the building of another. That's burglary, whether you take something or not. Larceny is the act of taking something that belongs to another. So often those would obviously go together. A burglar usually doesn't break into a building and come away empty. So you see burglary and larceny go together a lot. Obtaining goods by false pretenses, like that's fraud, fraudulently taking the property of another. And you can see in just these definitions how easy it is to have overlap between torts and crimes. Receiving stolen goods, that's a crime. Arson, that's the willful and malicious burning of a building or some other structure. Forgery, fraudulent making or alteration of any writing that changes the legal liability of another. So we think about checks, but you could forge a deed, you could forge an invoice, you could forge pretty much anything these days. Public order crime is another category. Those are things that basically affect the peace of society: drunkenness, prostitution, gambling, drug use, things like that. Public order crimes. White collar crimes are probably the category of crime that comes closest to what you would think we would be studying in business law. So white collar crimes are crimes that are often committed in the course of a legitimate occupation. So that's not like if my job is I'm a thief, that's not white collar crime. That's not within a legitimate business. But if let's talk about them. The first would be embezzlement. That's the fraudulent conversion of the property or money owed by one person but entrusted to another. So if I work at a bank and I'm taking money out, I have access to the computers and I'm taking money out of somebody's account and putting it into mine, that's embezzlement. That money doesn't belong to me. If I'm a clerk and somebody comes in to make a payment and I put the payment in my pocket, that's embezzlement. That belongs to my business. If the person who is doing the embezzling, even if they intend to return it, it's still embezzlement. So if I took that payment and put it in my pocket, and I'm the next day I'm going to put it in the cash register or give it to my employer or do whatever I'm supposed to do with it, it's still embezzlement if I keep it for a little while. So that is a little bit of a wrinkle on that. You heard of mail and wire fraud? Mail fraud used to be the bigger category of the two. Now wire fraud has way exceeded mail fraud in how often you see it. That's just using the mail or using electronic means to defraud somebody out of something. Has anybody been trying to reach y'all about your car's extended warranty? That's some wire fraud right there. Anybody been contacted by a Nigerian prince? That'd be wire fraud. I mean, I'm really OCD about my junk mail. I clean it out every day, and so I mean, it's hundreds of emails about something I've won, or I mean, and I wish that I wish somebody would prosecute these people that do it, but I know it. I mean, I know how hard that would be to track down people, but it's just so obvious. It's like you're it's so obviously criminal, and it's like, how can we just going to let people do this all day? And I have in my line of work, um, one of the things that I do is, well, this is getting off a little bit, but we got time. In Georgia, through probate court, you can get a guardianship of someone or a conservatorship. Guardianship is over the person, conservatorship is over the assets. So often what we do is we see elderly individuals who aren't able to make decisions for themselves anymore and they need a guardian, or they're not able to manage their money anymore and they need a conservator. And lots of times family members do that. But there are some situations where either the family members can't, or they won't do it, or somebody just has no one, and the court will appoint the county guardian to do that. So I've done some of that work before, where I've gotten appointed to manage somebody's money because there was no one else to do it. And it's in some instances it's been because somebody was getting scammed and they didn't know it. And have y'all ever had any family members or any experience with somebody getting scammed? They believe it. They get angry at the person who's blocking. I mean, there was a guy, and he was so mad at me. They're delivering my BMW today that I won. I've got to be here. It's coming. You know, and you're like, no, it's a scam. And they whatever's happened in their minds, they can't see it anymore. But I mean, I'm going to tell you, they believe it. And so these scam emails, I mean, the reason that you see them so much is they work. I mean, they don't work on most people, but they work on enough people to make it profitable. This guy sent $10,000 to some address in New York in cash in the pages of a magazine, is what she told him to do. And in his mind, that sounded totally legit. And we're like, that there's no way that's legit. But they use them. They'll be like, you go and take some money out of your ATM and you take it to this person. I mean, the levels that they'll go to are just, it's really depraved is what it is. So anyway, that's all wire fraud, mail fraud, wire fraud, all mixed together. Bribery is a white collar crime. So bribery of both public officials and bribery, commercial bribery, which is like, kickbacks or payoffs, or, hey, Caleb, if your company will use my product, then I'll kick you back some of what your company pays me. Put that back in your pocket. Sounds good? Yeah, I bet it does. One of the things to remember about bribery is that the crime of bribery happens when the bribe is offered. So even if it's not accepted, the person that offered the bribes is guilty of or could be guilty of the crime. The crime is not defined by the offer of the bribe and the acceptance. It's defined by the offer of the bribe. Once you offer it, you could be charged with bribery. This does happen pretty often, I think, in the commercial context. We don't really see bribery of public officials as much. One interesting thing for international companies is that there are some, in some other countries, bribery is not only legal but expected. And so if you're operating internationally, you've got to be cognizant of the definitions of however that's criminalized in that country or not. And you have to be very careful about that. Bankruptcy fraud is fairly common. If you declare bankruptcy, you got to list and disclose all of your assets. So if you're hiding something in a Jamaican bank account or in any bank account, that could be bankruptcy fraud. Theft of trade secrets. That's exactly what it sounds like. If you buy or possess trade secrets of another company, that is a crime. Even if you didn't steal them, but you have them and you know they were acquired wrongfully, you could be charged with theft of trade secrets. And those sanctions can get pretty serious in terms of fines and even imprisonment. Okay, insider trading. Um, that happened in the season of Suits that I'm watching now. Insider trading is when you buy or sell a stock or a security, or you make an investment based on information that is not public. So you guys have, I'm not sure how far along you are in your business curriculum, business school curriculum, but you know that any publicly traded companies, the whole system is founded on the idea that everybody has equal access to information. All right, that's the whole premise that it's built on. But there are some people that have inside information, like the officer of a corporation obviously knows what products they're developing, or knows before the public does if there are financial problems, or if their business is going out of business or has some risk or something like that. And so folks are not allowed to make or buy or sell stock, make trades, investments based on inside information. So like officers of companies have to, they have to disclose their stock sales to the SEC, the Securities and Exchange Commission, not the Southeastern Conference. And they're, they're subject to some scrutiny in their trades. But I think it is a crime that is it's hard to catch. I think once they catch you, it's maybe a little bit easier to prove. I say it's hard to catch because if Jesse works for a pharmaceutical company and he and I are he's my nephew, and he tells me over at Thanksgiving, hey, we've got this COVID cure drug that's about to hit the market probably mid next year, and so I go out the next week and buy stock in his company. It's going to be hard for anybody to prove that I did that. If I buy $5,000 of stock in Jesse's company, that's not going to raise anybody's eyebrows. But if I buy, I don't even know, a huge, huge chunk of his company's stock, then that might catch somebody's attention. So I think it's hard to catch, but not necessarily hard to prove once they start looking at it. But maybe so. Jesse and I could both swear under oath that he never told me about that drug, and unless there's a written record of it or somewhere, or somebody heard it, it's still going to be hard to prove. And maybe Aunt Alice heard us and she testifies against us at trial, but we deny it. She's the only witness. Still hard to prove, I think. It is a very serious crime, though. If somebody was convicted of insider trading, then they're almost always going to jail. So it's nothing to play around with. But you might think, well, I don't know any CEOs of major drug companies or anything, but it could be as innocent as overhearing somebody on the subway or at a baseball game talking about their research and development or something that's happening with their company. Even if you didn't intend to get the information, you just overheard it and it accidentally, you still can't trade on it. If I'm on the subway and I overhear a person talking on their phone, and based on that conversation, I infer that something's happening and I trade on that, they're still going to have to prove it against me, which would be very hard. But it's still illegal for me to trade on any. The key to that is you can't trade on anything that's non-public. So you can't use any non-public information. Organized crime. So this is what we would call the mob or the mafia, which is not really defined in the law, but we would loosely all associate the mafia or organized crime with people who are running businesses, crime businesses. Their business is crime. They might dress it up as something legit like waste management. Is your company waste management? I'm just kidding. Sanitation. I'm just kidding. I don't think Caleb's in the mafia, but you never know. Um, the Columbus, yeah, the West Georgia mafia. Well, now Phoenix City had a mafia. Y'all aware of that? What, Yulia? You didn't know that? They really did. And I mean, I'm not from here, so I don't know the story as well as some others, but it went on. It was too bad JJ's not here. We might get his dad to talk about that when he comes. But I mean, it went on. It's more recent than you would think. It's not like last 20 years or anything, but it went on longer than you would think that would be allowed or something. Yeah, yeah. And what was their? They were running what? Was it liquor? Gambling. Okay, gambling liquor. All right. Yeah. So. Yeah, I think that the Alabama National Guard raided Phoenix City and restored law and order. Yeah, and there's stories about there's certain family names that are associated with it, and so on and so forth. But anyway, um, so organized crime. Yep, not just a New York or New England type thing. Across the river. Um, Wait, say that. What's your question? Um, I think they could probably use it against cults. The thing about RICO is they designed RICO to be able to nab or target or prosecute mafia, but now they've expanded it. That's what we were talking about. That's one of the things. That's what Trump is charged with um, violating in Georgia is our racketeering laws. So I think yeah, it could be used against cults. Um, and we'll get to RICO in a second. Let me hit money laundering. That's just when you have a legitimate business and an illegitimate business, and you're taking the money from the illegitimate business and washing it, laundering it through the legitimate business. So let's say I've got a restaurant and I'm also dealing cocaine, and I just take my cocaine profits and I put that in the register and I count that as um, money that I've made at my restaurant. So I wash it, so to speak, and it becomes legitimate profits of my restaurant. Um, so RICO, which is the racketeer, it's defined as Racketeering Influence Corrupt Organizations Act. This is the one that was designed at the mob, and basically things that the mob were doing would be maybe individually not serious crimes, but grouped all together their enterprise was a criminal enterprise. So RICO kind of said if you are engaged, it defined these smaller crimes, that if you're engaged in more than one of these, then you could be charged under this racketeering RICO statute. So I think that could apply to cults, especially if they were any illegal aspect of it. I think if they could prove more than one, then they might could use RICO to do it. So, like your outline says, RICO incorporates 26 federal crimes and 9 state felonies. If a person commits 2 of these, then he or she is guilty of racketeering activity. So, whereas before RICO, they might could convict you of doing these 2 crimes, but maybe they were relatively minor and the penalties weren't serious. But once RICO grouped them together and said, if you commit more than one of this list of crimes, then your punishment goes way up or gets more serious because you're engaging in a criminal enterprise. That's kind of how they did that. I guess. I mean, we talked about this with the Trump cases. The criminal enterprise would be trying to not overthrow, but well, I guess overthrow, change legitimate election results or something like that. Remains to be seen how that plays out. So the gag order, yeah, the gag order was in the DC case, which is what was the DC case? What is he charged with in the DC case? I can't remember, but the judge actually read, somebody was live tweeting, it was pretty interesting. She seems pretty fair to me. And she said, look, he can say anything he wants to about Biden. He can say anything he wants to about the Department of Justice, that it's corrupt or that he's being persecuted. His freedom of speech extends to that. But he can't threaten witnesses. He can't threaten like the prosecutor's family. He can't say things that might incite violence against somebody else. He had tweeted that the law clerk of one of the other judges in that area was the girlfriend of Chuck Schumer and corrupt, and she was like, it's off limits to talk about court staff. What else did she? Anyway, I thought it was pretty fair what she said, because the things she said he can't talk about were things that every defendant can't talk about. So she didn't make special rules with respect to him, which is kind of what sounded like what he was asking for was, because I'm a political candidate, you can't really restrict what I'm saying. And she said, you're right, I can't restrict what you're saying if you want to criticize your opponent or things like that, but I can hold you to the same standard as any other criminal defendant, which is we can't be intimidating witnesses or you can't talk about the prosecutor's wife and, things like that. So I thought that was kind of interesting. But yeah, he got a partial gag order. She granted it in part and denied it in part. What do y'all think? I think he's going to I think he may have overnight. I don't know. I haven't looked at the news this morning, but he'll if he wouldn't tweet impulsively and he thought about it and had advice, then they could craft those tweets to like approach the line but not go over them. But I mean, like that's not how he operates. I feel like he's just tweeting, and we'll see. But what'll be really, really interesting is if he violates it and she punishes him. Because what does she do? Does she put him in jail? Does she fine him? I mean, like if she puts him in jail, then what happens next? We have a civil war. I mean, like that almost would be more dangerous to the public than, I mean, I don't know. It's fascinating.
The influence over people that he has. Because he might claim, what he's saying is free speech for everybody.
Yeah.
It's the people that.
Well, he is. I did say he is impulsive, but there is some genius to it, because he does walk the line in a lot of things where he could be like, I was just saying this. I didn't overtly threaten anybody. And you're like, well, but we know what you meant, but you can't really get in trouble for, we know what you, I mean, I don't know. It's a very gray area, and he's very masterful in how he maneuvers around that gray area, I would say. All right, so let's go to defenses to criminal liability. So hopefully by now you're used to that. We're going to have torts, crimes, these things, and then we're always going to have some defenses to them. Justifiable use of force. This is always an interesting one to me. This is self-defense. Self-defense is defined by each state. So Georgia's self-defense law would look different than Connecticut's self-defense law, different than New Mexico's. Your discussion question this week has to do with Florida's self-defense law. They have a pretty strong one, and it's fairly recent. And it is very pro self-defense, pro landowner, homeowner, that type of thing. And so the discussion question this week just sort of tells you what Florida's is and asks you for your how you feel about the way Florida handles self-defense. Generally speaking, again, this isn't the law of one particular state. This is generalized, but people can use the amount of force that's reasonably necessary to protect themselves, their dwellings, or other property, or to prevent the commission of a crime. So again, we've got some language that's subject to interpretation in here. We've got this word reasonable again. Reasonably necessary to protect themselves. And that idea is that if Dez comes at me with a stick, is an assault rifle reasonably necessary for me to defend myself against the stick that he's coming at me with? Probably not. If 1,000 people are coming at me with sticks, then maybe an assault rifle is a little bit more reasonable, although we're still pushing it. But that's kind of how reasonable comes in. Deadly force can be used in self-defense sometimes, but there have to be some things present. There has to be a reasonable belief that imminent death or great bodily harm will otherwise result. That word reasonable again, imminent death, great bodily harm. These are things that are very dependent on facts and circumstances. The attacker has to be using unlawful force. The defender cannot have initiated or provoked the attack. That should be obvious. And the degree of force has to be kind of proportionate to the threat. That's where that idea of reasonableness comes into play. Necessity. A defendant could be relieved of any criminal liability if the act was necessary to prevent an even greater harm. I am doing 200 miles an hour down University Avenue because I'm trying to get Josh to the hospital. I get charged with speeding or reckless conduct or whatever there is, but I might say, well, it was necessary for me to break the law because I was trying to save his life. Because he got beat with Dez's stick and he didn't have his assault rifle on him, and see what happens there. So that's necessity. Yes, sir. She was speeding with her emergency lights on, and he crashed into her. Oh, she was going to the hospital to have the baby. Is this local? Is he liable? Well, assuming he didn't do it on purpose, then you'd be looking at negligence. You'd be looking at a couple things. One is negligence. He has a duty to pursue safely, so to speak. So could be if he breached that duty. I'm not sure if he has any sort of immunity. Are there any public safety exceptions that would apply to him if in doing his job, he personally is probably not liable, but his employer, the city probably, or could be. That's a great question. I think I need to know more about it, but.
It'd be the same instance if you were
Yeah. Well. Oh.
I think that's what he didn't know what was going on.
Yeah, I don't. He has a legitimate public interest in stopping somebody speeding and eluding pursuit or whatever. I mean, she's not stopping. The law is she's got to stop. So I don't know that he could be liable unless he was just so reckless or negligent about the way he did it. But that's really tricky. I'd be interested to know that. But I would think that the fact that she was breaking the law, I mean, necessity might be a defense for her, but I don't know that that means that she can't be stopped. I think he could try to stop her if she's breaking the law, if he had no knowledge of why. That would be my thought. Insanity defense. So this is going to be defined by each state too, but generally speaking, if the person has a mental disease or defect, such that they lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. What kind of evidence do you see us needing in court to prove or disprove an insanity defense? Who are we going to need to testify? Not just the person. I mean, you can't raise your hand and say, oh, I was insane that day. I'm good now, but I was insane that day. Yeah, some sort of mental health professional. That's right, Jesse. The person would have to be, if you're going to use insanity defense, you have to declare that ahead of time. And then if you're going to use the insanity defense, you would not use it unless you had your own expert witness that was going to come testify that you were in fact unable to appreciate the wrongfulness of your conduct that day. And then that would also give the prosecution the opportunity to have you examined by their expert, and their expert could testify yay or nay. We could have, very often we'll have experts that have differing opinions on whether or not you could form that capacity or not. Hard to prove, I think, but certainly possible. It's just hard when any of the element of proof involves something like whether somebody had mental capacity. I mean, that's just tough to get inside somebody's head. And that really extends in criminal liability when we talk about intent. Unless the defendant says, yes, I intended to do that, then we're always making an inference, right? Based on their conduct or their words or actions that they intended to do it. I mean, I pull out my gun and I shoot Dez. I'm not going to admit that I intended to do it, but we're going to infer from my conduct that I did. And that's always kind of easier in some cases than others. All right, mistake. Mistake of fact could be a defense if it negates the required mental state. So let's say that larceny, the larceny statute requires intent. So I had to know that that phone was Yulia's and I had to intend to take it. Well, let's say that it was sitting right here and it's exact same model, exact same color, exact same case as mine, and I thought it was mine. That might negate the element of intent. So I might not could be charged with larceny in that situation because I made the mistake of fact negated my intent. Mistake of law is generally not a defense. So it would not, so I could say, well, I didn't know the speed limit was 35, officer. So therefore I didn't have the intent of speeding because I didn't know it was 35. That doesn't work. It could negate my intent, yes, but we're all presumed to know the law, even if we don't. You're presumed to know the law. That's why I said you got to be careful in things like bribery. Somebody from another country where bribery is legal could come here and offer a bribe, not knowing that bribery is illegal here, and that is not a defense. So usually mistake or ignorance of the law is not a defense. You hear that saying sometimes. Mistake of fact could be a defense. Not always, but it could be. Duress is a defense, and duress involves when somebody is under threat for their safety or the safety of someone else, and that because of that threat, they're doing something that they wouldn't normally do. The easiest example of duress I can think of is a gun to the head. Sign this check fraudulently or I'll shoot you. I'm doing it under duress. Did I forge a check? Yes. But I might have the defense of duress. In other words, it wasn't done by my own free will. Duress excuses a crime, but usually if the defendant reasonably believed in the immediate danger, and the judge or the jury concludes that the fear was reasonable. So that's going to depend on the facts and circumstances. But um, I couldn't say, for example, well, I wrote these checks fraudulently from my business's account because I believed my boss would fire me if I didn't. I mean, that's maybe not an imminent threat of harm or danger enough to constitute duress. If my boss is holding a gun to my head, then that's different. Entrapment, y'all have heard of entrapment before. That is when a law enforcement official kind of induces or entices or causes a person to commit a crime that they weren't already going to do. So in other words, they were led into it, basically. You can't use an entrapment defense if you were going to commit the crime anyway. So let's say that I'm going downtown to buy some illegal drugs, and I go to an area where I know the drug dealers hang out, and I just and undercover law enforcement walks up to me and offers to sell me um, some illegal drugs, and I buy it from that law enforcement officer. I might argue entrapment, but I was still down there. I was predisposed to go buy some drugs down there anyways. That might not work as a defense for me. They'd have to prove that I was predisposed to buy it. And if I had another legitimate reason for being in the area, maybe they couldn't prove predisposition. But maybe if I couldn't come up with any other reason why I was down there, they might be able to show I was predisposed to do it in the first place. Maybe I had a bunch of cash on me. Maybe I don't know. But again, an overarching theme of criminal law is, and I hope something that's been illustrated this morning to you is, the government still has to prove all this in order to convict you of a crime. They got to prove every element of it, and not only do they have to prove every element, but they got to do it beyond a reasonable doubt. So there's a lot of wiggle room in proving all these elements beyond a reasonable doubt. There just is. You've got human beings that are either the judge or the jury, and reasonable doubt. I mean, if you got a good criminal defense lawyer, some cases that if you hear the facts, you might think, well, that's pretty cut and dried. Maybe not so when it gets argued before a jury. So beyond a reasonable doubt required for all these crimes. Another defense is statute of limitations. Statute of limitations is that some crimes, or there are laws that say that you can not be charged with a crime after a certain amount of time has passed. Murder famously has no statute of limitations. That you can be charged with murder 100 years after the crime. But there are some. No, I mean I don't have one example off the top of my head, but maybe I don't know, some sort of theft that after 10 years they can't charge you with it. I need to have a good example in my outline of that, but I can't think of one off the top of my head. And then another defense is immunity. Some people from other countries might have diplomatic immunity if they're government officials. The immunity that we're most familiar with is the immunity you get from being offered immunity by the government for your testimony or cooperation in the prosecution of a crime. So that would be a defense to you being charged with a crime, is they gave me immunity for this. That happens all the time. We will, you cooperate with us, if you testify against so-and-so, then you're immune from being prosecuted with this crime. We see that in Law and Order. You watch Law and Order, that happens almost every episode. They're going to use immunity on somebody. Immunity, I guarantee you, has been on the table for all of these people that have been indicted with Trump in the Georgia case, because the government's case gets way stronger if they can get one of these folks to flip on Trump and say that he knew that he knew that the things he was doing was wrong, or he knew that the election was, that there was no fraud or things like that. There's one guy that's taken immunity or took a plea deal, and he was one of the guys that he's a minor co-defendant. He was from Coffee County, Georgia, when they went down there and Coffee County let them see the voting machines. He was involved in that somehow. I think that's his role, but no big fish have flipped as of yet. But I wouldn't be surprised if that happens. All right, let's talk about constitutional safeguards and criminal procedure for a second. Let me look and see how much we have left. Okay, we're good. So you should all, I think you would all are familiar on some level with these constitutional safeguards and procedures. One is that Fourth Amendment protections. This is the protection against illegal searches and seizures. So general premise being that we are safe in our private lives and our private dwellings, our cars, from being searched by the government without a warrant. So to get a warrant to search our private areas, be it cars, homes, person, law enforcement first has to go and get a search warrant from a judge. And in order to get the search warrant, they've got to tell the judge enough facts that would make up probable cause that the search would find the evidence that they're saying would be there. So you don't get like general search warrants where you go say, hey, judge, we think Tebow's dealing again. We would like to be able to search his office at CSU, his office at work, his law office, his home, and his car. Or we just think Tebow's up to something. We would like to search all these places. You can't do that. They've got to tell the judge facts that would rise to the level of probable cause. Hey, we've got a confidential informant that bought drugs from Tebow. We've got we have phone recordings that where he's dealing drugs. We've got witnesses that say they bought from him, things like that. You got to have some sort of probable cause. Now, when the law enforcement folks go to a judge to get a search warrant, it's not recorded. It's not, there's no transcript of the conversation between the judge and the law enforcement officer. There's nobody there representing the rights of the person who's going to be searched to question the law enforcement official on what their evidence is. So those conversations could depend on what judge they ask. It's conceivable that you could have two judges, and if you presented the same facts to each judge, one might say, yeah, I'll give you a warrant for that. Another one would be like, no, that doesn't sound like enough. So sometimes it could depend on what the judge says. That doesn't mean that they could go and lie. They still, after the fact, would have to say what their probable cause was, okay? But I just point that out to say that's an area where it's a little bit secretive, maybe not be the right word, but that's just how that all goes down. So that's Fourth Amendment protections. Keep in mind, too, that on Fourth Amendment protections against unreasonable searches and seizures, that only applies where a search would violate an area where somebody has reasonable expectation of privacy. My office, my home, my car, my person right here. If I leave, I'm trying to think of a place where I wouldn't have a reasonable expectation of privacy. If I had a backpack and I leave it open where anybody can see into it, then a law enforcement officer who walks in and sees a bag of cocaine in my backpack in the classroom sitting out here on this desk, they don't need a search warrant to go through my backpack. I don't have a reasonable expectation of privacy in something that's open. I have a reasonable expectation of privacy in a closed backpack, definitely, but not necessarily one if it's just open and all that. So that you do have to have some sort of it has to be somewhere where you have a reasonable expectation. Yes, sir.
So, if an officer said they had a reason to search the vehicle, and it was, could it be proven later that they didn't actually have?
Yeah, they've got a. Yeah, they've got a. So, their probable cause could be questioned later.
So anything they find.
Yep. So, if at any point along the way, we're going to talk about this, if not today, then Thursday, but if any point along the way, the law enforcement official did something wrong, then anything that they found is not admissible. It's not usable. It's excluded at trial. They cannot use it. That's called the fruit of the poisonous tree doctrine. So any fruit that they get as a result of something they did wrong, out. Cannot use it. So if the search, if it turns out that the grounds upon which they got the warrant were not, they lied to the judge or they didn't have any probable cause at all, then anything that the search yielded is out. Same thing like if the law enforcement officer arrests me and forgets to read me my Miranda rights. Anything that I say after, if I confess, but they never read me my rights, the confession is out. That'd be fruit of the poisonous tree. So that takes us to Fifth Amendment protections. The ones that you're probably most familiar with, double jeopardy. You can't be charged with the same crime twice. So if you've been tried for a crime and found to be not guilty, then you can't be charged with that again. Just as an aside, a lot of times I want y'all to use the right terminology. If somebody goes to trial and they're not convicted, then they've been acquitted or they've been found not guilty, but they haven't been found innocent. They just were found not guilty. We like to say that like they were found innocent, which is kind of unfair because if I go to trial and they can't prove it on me, I'm going to be like, I'm innocent. But I wasn't found innocent. The jury just said I was not guilty. It'd be nice if the jury could say innocent. He was found not guilty in the criminal trial. In the civil trial, he was found liable.
But he wasn't found innocent.
He wasn't found innocent. He was just found not guilty. You're never found innocent. You're either acquitted or you're found not guilty. I mean, acquitted and found not guilty are the same thing. Say that again. That's not fair. I know. I feel like, although on the other hand, we do say that you're innocent until proven guilty, right? So I guess I could say I'm innocent because I wasn't proven guilty, but the jury didn't find me innocent. I don't know. Maybe I shouldn't have brought that up. That's a distinction without a difference, really. Fifth Amendment also protects against self-incrimination, so we're not required to testify against ourselves. You'll hear that. People will say, I plead the Fifth. Fifth Amendment guarantees the right to due process. That just means that the law has to be carried out in a fair and orderly way. So not being read my Miranda rights would be a violation of due process. If the government didn't follow the criminal procedure laws of the state of Georgia correctly, then I might be denied due process. If I wasn't given the right to cross-examine witnesses, I might be denied due process. Let me say this too. I want to back up to defenses for a second. We went through a whole bunch of defenses. Those aren't the only defenses. There are more. But it's also always a defense to point out that the government didn't do something that they were required to do by law. I didn't get my Miranda rights. I was denied seeing my lawyer. They didn't have probable cause. They didn't turn over all the evidence. Those are always defenses you can use. We also didn't talk about the main defense that people use, which is what? I didn't do it. I didn't do what they say I did. That's obviously also a defense. Let's hit the 6th and 8th Amendments. 6th Amendment guarantees the right to a speedy trial, trial by jury, the right to cross-examine witnesses, and the right to have a lawyer. So you do not have a legal right to be appointed a lawyer in a civil case, but you do in a criminal case. So you'll never see a criminal case where the defendant doesn't have a lawyer because they weren't given one. A defendant could choose to not have a lawyer. That'd be a dumb thing to do, but they could. But if a defendant wants a lawyer, then they're guaranteed the right to one. That would be the public defender in the state of Georgia. There's an office of the public defender, and they have a bunch of lawyers there, and their job is to represent defendants who can't or won't hire their own lawyer. So even if I make enough money to hire a lawyer, but I want one to be appointed for me, they'll give me the public defender. The exclusionary rule and the Miranda rule, we kind of hit that already. The exclusionary rule would be, that if any evidence is obtained in violation of any rights under the Constitution or state law, then that evidence is out. Miranda rule, y'all are very familiar, I would hope, with the Miranda rights because you hear those in movies and TV all the time. You have the right to remain silent. Anything you say can and will be used against you, that sort of thing. You have the right to counsel. All right, I'm going to stop there for the lecture, and then let's talk for Thursday. I'm gonna finish the outline on Thursday. We've got a couple more pages of it. We're going to talk about some cybercrime things, and then I'm going to have a little fact pattern that we're going to talk about, and we're going to identify certain crimes like we did in torts when Johnny and Rusty were going at it. And then you have a case, Carpenter versus the United States, which involves surveillance kind of activities. So I do want you to read that because we're going to talk about that, and that will be on your quiz. So for Thursday, read Carpenter. You have a discussion question. That's all. See y'all Thursday. Yep.